Hello, my name is Professor Joseph Ragno, and I'm happy to welcome you to MPH 620 Public Health Policy and Law and HA 609 Health Policy and Law. These classes are cross listed and will be delivered online this summer. Because this class is being delivered in online format, we will not be able to meet as a class. Nevertheless, we will remain in close touch over the next 11 weeks using Moodle and email. You will note in the introductory section of the Moodle for this class references to the class syllabus, which you should review in great detail and with care, a schedule of weekly assignments and forum, and guideline for written assignments. All written assignments, the major ones at least, must be done in APA format. As graduate students, it's my expectation that you're familiar with this format, but in the event that you need to brush up on it, I have appended to Moodle in the introductory section a resource called Purdue OWL, which I'm sure you're familiar with. But I will expect that your written assignments will conform with APA at this point. The weekly schedule will be something like this. Each Sunday before a given week, I will open up the module for the coming week. This will give you access to the reading assignments should you choose to get a jump on them, as well as the written assignments, which will typically be questions from that chapter, and also the weekly forum. The forum will be on a topic or a prompt that I will supply in the module for that week, and the schedule of weekly assignments and forum will describe in detail what I expect of you with respect to the forum. In an online class, the forum is of paramount importance because we will not be coming together as a class. So, in order for me to get a feel for whether or not you are absorbing the material and applying it to the real world problems that I pose to you in the forums, I will be looking to your responses for that. In terms of the standard weekly written assignments, they will all be due by Sunday at the end of each week at 11:59 and will be submitted through the provided Dropbox. The forum will require a primary post by each student, followed by 2 secondary posts commenting on the primary posts of their classmates, of 2 classmates. The primary post will be due each Wednesday evening by 11:59. That's midweek. And the 2 secondary posts by Sunday evening at the end of the week at, again, 11:59. I will communicate with you frequently through announcements on Moodle and through emails. Some of the emails may be individual and some may be to the class as a whole. You should also feel free to communicate with me and to get me questions that are on your mind or clarifications that you seek through email. My email address is noted on the syllabus. It's going to be very important for you to consult or access Moodle frequently during the course of this class and to check your email on a daily basis at least. I do myself check my emails frequently, and I will try to respond to your emails within 24 hours of receipt. However, I will post announcements about assignments and clarifications, and I may change schedules from time to time. And all of that will be done through Moodle announcements or emails. And you'll be expected to check in on those and be aware of them. Let's start with an introduction to public health law. I don't know how long it's been since any of you have had a political science class or a history class which delved into our Constitution, our American form of federalist government, the separation of powers, and the Bill of Rights, which guarantee us our individual freedoms. However, all of those things and more will be foundational for an understanding of public health law, where the power comes from, and how the Constitution limits the government in its exercise of those powers. So we're going to begin by reinforcing a working knowledge of the structure of our state and federal governments, and that all begins with the United States Constitution. If we were meeting in person, I would probably spend 10 or 15 minutes or more gushing about the Constitution. It is, as a lawyer myself, this Constitution is a model for other constitutions around the world. It is beautiful in the way it was brought together as the result of compromise between different parties, different factions among our founding fathers, but it is also exquisite and delicate and finely balanced when it is being properly administered. We're going to learn about how all of that comes together. We're going to do a refresher on how laws are created by Congress. We're going to talk about the structure of Congress. We're going to talk about the 3 branches of government, those being the executive. Think of that as the president at the federal level and the governor at the state level. Legislative, of course, at the federal level, we're talking about the Senate and the House of Representatives, and the legislative branch or judiciary, I'm sorry, not legislative, but the judicial branch, which would at the federal level be at the very top of the pyramid, our United States Supreme Court, below it a Court of Appeals, and district courts below it. State court systems are constructed similarly for the most part. We're going to talk about how each of these branches of government constitutes a check and a balance against the others so that no one branch of government becomes dominant. This has been on the minds of constitutional lawyers since the Constitution was first drafted back in and adopted in the 18th century. And there were factions at that time who were in favor of a very strong executive and others who were resisting that. At the same time, there were factions who were in favor of a very strong central federal government and others who were more interested in preserving states' rights. Our Constitution represents a compromise between all of those positions. And it's again, when it's working, it's a thing of wonder, and when it's not working, like in recent times, it seems like not a good system at all. But we'll talk about how these things all come into play in the public health effort. Of course, we'll talk about COVID-19 because the news is providing real world examples for us on a daily basis as we see the president and his COVID committee addressing the nation less frequently in the last week or so, but at one point every day, as we see governors like Governor Cuomo and Mayor de Blasio in New York and Governor Murphy in New Jersey, getting on television and issuing executive orders and discussing their view of how we're doing in combating the COVID-19 pandemic. We'll see government in action. And we'll also see the friction between the federal and state governments in this process. Hopefully, at the end of it, you'll be able to describe the federal legislative process from the introduction of a bill to the president's desk, where the president signs it into law. We'll talk about the regulatory process which follows that. We'll try to understand the limits of the power of the executive branch. We'll understand the role of the judiciary in adjudicating the rights of people who are affected by these laws and also checking the power of the legislature and the executive branch. And we'll look at the mechanics of checks and balances and discuss why it's necessary to preserve individual freedoms. As we get on in the course, we'll get more into the Bill of Rights. The Bill of Rights are the first 10 amendments of the United States Constitution, and for the most part, our individual freedoms, the things we think of as freedom of speech, freedom of religion, the right to bear arms, due process, equal protection under the law, the right to a jury trial, the right to be free from unreasonable searches and seizures, and many other things are all embodied in those 10 amendments. And these will come into play big time as we discuss public health mitigation efforts and the power of the government to act in the face of an epidemic, or in this case, a pandemic. As always, these efforts will create some friction as it relates to individual freedoms. There will be some debate, and sometimes there'll be litigation where courts are required to make a decision about whether or not a governmental effort has gone a little bit too far, or whether or not it's within the power of the government to act under these extraordinary circumstances. I'd like to begin with a brief overview of public health law and to describe how the course will be broken up. I anticipate that the first 6 weeks of the 11-week course will be devoted to public health law and policy. The remaining weeks of the course, weeks 7 through 10 or 11, will be on health law and policy. This will deal with the bioethical, economic, and corporate aspects of healthcare. Public health law and policy, in order to understand it, requires that we understand a little bit about the history of public health. Public health is not something which is a 20th or 21st century phenomenon. It is something that human beings have grappled with for as long as they have lived together in communities. We must also come together on a definition of what public health law is so that we can ensure that we're all talking about the same thing. So for purposes of this class, public health law is that law which assures the conditions for a community or a society to remain healthy, and which also prescribes limitations on the power of government to act in the public health field. We'll talk about the public health issues of our time. And of course, COVID is first and foremost. It's in the news on a daily basis. But there have been others, and there will be others in the future. And not all of them have to do with infectious disease. One of our exercises in week 1 will be to have you describe 3 public health issues that are of importance to you, ranking them from 1 to 3, and providing some justification for your ranking. We'll also look at the governmental tools which are used to address public health issues, and these would be the legislative process, that is, the process by which laws are created, regulation, and the court system. Overall, we'll be studying to some degree the United States Constitution and the Bill of Rights and the provisions in the Constitution which are impacted in the field of public health law. No treatment of public health law is complete without some excursion into the history of public health. And I like to do this in particular because by background, I was a history major in college. So I'll work history into just about anything I teach. So let's begin with the biblical era and the 10 plagues of Genesis. Everyone knows that according to the Bible, God punished the Egyptians by sending 10 different plagues. I've got a separate PowerPoint which is on Module 1, which you might enjoy taking a look at. And there's also a New York Times article referenced here, which describes possible scientific and natural causes for each of these 10 biblical plagues. Also, think about, if you're familiar at all with the New Testament, the treatment of lepers and leprosy at the time of Jesus. Lepers being pushed to the margins of society. We should probably think about that as primitive attempts at social isolation and separation. The fear in society being that leprosy was contagious. Public health efforts in the Roman Empire included the building of sewers and also the act of Julius Caesar in draining the swamps around Rome. These swamps around Rome in the early days bred mosquitoes and, as a result, malaria. So one of Caesar's great public works projects was to drain the swamps, literally. And you can see a photo of an ancient aqueduct here. An aqueduct would have been built by the Romans to bring sanitary water into their big cities. And this was important. The water would have come from mountain ranges far away from Rome and the other big metropolitan areas. A little bit further on in the 6th century, when Justinian was emperor, we had a plague, bubonic, which had a huge social and political impact. It's estimated that 100 million people died. Possibly as much as 1/2 of the European population was infected by this plague. And it is the fall of the Roman Empire is to some degree attributable to this plague. In the 14th century, we had the Black Death and the concept of quarantine. Quarantine coming from the Italian word quarantena, meaning 40. So ships coming into Italian ports would be held out in the harbor for a period of 40 days because the school of thought at that time was that 40 days was sufficient to ensure that no one on board nor the goods on the ships would be dangerous after the 40-day quarantine period. We must also look at root causes for public health issues. When we think about any of them, whether they be infectious disease or the lack of sanitary water supply, we think about agriculture. Agriculture, for the first time, brought people to a standstill, had them settle in to particular places geographically so that they could cultivate the land. Also, agriculture brought human beings into relationships with animals which did not exist prior to this. So human beings living near animals may have given rise to many of the infectious diseases and vulnerabilities we have to this day. Urbanization is a root cause because urbanization, the establishment of cities, brings large populations of people together to live in close proximity, which aids the transmission of disease and also puts a tremendous burden on the sanitary sewer and water supplies. Commerce and trade is a contributor because as ships and people move about the globe, even back in those days on ships or overland, they carried with them things which could transmit disease. Think about rats and ships and fleas. Most people agree that the plagues of Justinian's time or the 14th century or even today may have had something to do with the interaction between human beings and animals. In the case of the Black Plague, it's believed that the disease was carried by rats on ships around the world along the trade routes, and that the insects who rode along with the rats and bit human beings may have been the middle piece required to transmit the disease from rats to human beings. In order to begin discussing public health law and public health policy, we must settle on some definitions. What is a public health crisis? Calling something a public health crisis or a national emergency invokes the awesome powers of the government to act to fight against it. In the case of recent times, President Trump has called the opioid crisis a crisis of public health. COVID-19, of course, H1N1. What about the vaping epidemic among teenagers? What about the failure to supply clean water in communities like the community of Flint, Michigan? Many of these things are public health crises which, when properly recognized, trigger the power of the government to act to combat it or counteract it. We will, as I mentioned before, in the first week's assignment, develop a list, and hopefully over the course of the 11 weeks, we will touch on each of those. It is possible that you will pick one of the issues that you identify this week as the topic for your final paper, which would be subject to my approval before you go on and do it. We are primarily talking about the law of public health, but there's also an ethical consideration. And there are certain steps that public health officials, lawyers, governmental officials must consider when they think about the measures that government brings to bear to combat a public health crisis. So, step one, most fundamentally, is to identify goals. What is it that we're trying to accomplish? Sometimes it's obvious, and sometimes it's not. Secondly, we need empirical support for the measures. How do we know they're going to work? This relates to having a good, solid, well researched, science based reason or rationale for the measures which are going to be adopted. You'll remember that with regard to COVID, um, the president had been touting a particular medicine, hydroxychloroquine, uh, as a treatment for COVID 19. Many of the doctors, even those on his own task force, were not so sure that it would work and were absolutely sure that it had not yet been tested scientifically. Uh, Remdesivir is another one which shows some promise, but it will have to go through clinical trials before it can be properly implemented and safely implemented. So they'll have to know that it's safe and they'll have to know that it's effective. Three, we look at the burdens which are imposed because the burdens can be significant. They can be burdens which change our day to day lifestyle, but they can also impact our individual freedoms and rights under the Constitution. They impact privacy, liberty, social justice, the right to worship, freedom of speech, uh, even the right to bear arms. And I'll go through all of those as we move on in the course and we think about the relationship between public health measures and the constitutional rights guaranteed to us. Alternatives, number four. There must be alternatives considered. Is there a better alternative to the one being proposed? Is there a less onerous, a less burdensome way to accomplish the same goal? Given two remedies for a public health crisis, which would both be effective, but one is more burdensome than the other, ethically, we should choose the one which is the least burdensome. Five, equitable distribution of benefits and burdens. This relates to how the burdens that are imposed by government impact segments of the population. Would it be fair, for instance, to say that because COVID 19 is said to have originated in China, that all people of Chinese descent should be quarantined or isolated? The answer to that is clearly no. That would be inequitable, it would be unreasonable, and it would be unsupportable. It would be unconstitutional. Six, finally, do the benefits outweigh the burdens? Sometimes the remedy is worse than the cure. So the public health officials and the lawyers and the governmental officials should always be thinking about the proposed remedies in terms of how they weigh out in balance against the harm that the public health crisis is causing. They wouldn't want to cut off their nose to spite their face. And we'll see examples where a public health remedy or measure could be so onerous and so dramatic that it goes far beyond that power granted to it by the Constitution and the law. And then finally, we'll look at the tools used by government to address public health issues. Of course, medical research is at the top of the list. We have to understand the crisis medically. Most public health crises have a medical root, a science root. Epidemiology, of course, when we talk about COVID 19 and infectious disease in general. But even vaping among teenagers, there's the physical impact on the respiratory system. There are psychological impacts. When we talk about the opioid crisis, of course, medical research is important. The other tool is legislation. Typically, in response to medical research, legislation is started. Congress will get together, or a state will come together in its legislature and through its governor and create new laws which address the problem. Once laws are created, regulations often follow. Regulations will provide a roadmap, so to speak, for public health officials and governmental officials to administer the law which is passed to address the public health concern. Public service messaging is a big deal. There's quite a bit of that now about social distancing, wearing masks and gloves, not traveling unnecessarily, keeping a distance. Um, this is done through all of the media, print ads, electronic ads, radio, TV, on the computer, through social media. And it's most important that people understand the seriousness of a crisis and how they can best address it by adopting the measures recommended by government and science. Education is primarily preventative because many public health crises can be addressed through education. They can be prevented, in fact. If you want to think about childhood obesity as a possible public health crisis, and many people believe that it is, then education is important. Teaching kids to eat the right foods in the right amounts, teaching them about nutrition, teaching them about exercise and fitness, teaching kids to avoid drugs, and teaching kids to maintain healthy lifestyles, all address public health concerns and prevent them. Can you think of others? Where do public health powers come from? Well, in general, public health powers come from the United States Constitution. The Constitution is the fountainhead of all public health powers. There are four main concepts which come out of the Constitution in this field, which must be understood. One is federalism, which is the allocation of power between the federal government and the states. The second is the separation of powers. That's the establishment of the three co-equal branches of government. The third is preemption, which prioritizes the laws of the federal government over those of the state and local governments. And the fourth is the Bill of Rights, which guarantee individual liberties and impose strict limits on how far the government can go in exercising public health powers. Federalism is important for many reasons. First of all, when you look at your Constitution, and I have attached that to Moodle up in the introductory section as a resource which you will use throughout this course. If you look at the 10th Amendment, the 10th Amendment is what we call the Reserve Clause. The 10th Amendment reserves to the states the power to regulate matters related to health, safety, and the welfare of citizens. This means that, for the most part, public health measures are the responsibility of the states, not the federal government. However, the federal government also has power to regulate in these areas, and some examples are Social Security, Medicare and Medicaid, Centers for Disease Control, and occasionally the state and the federal government run into conflict where both are trying to regulate in the same area. You'll recall that recently during one of the COVID-19 task force daily briefings, the president, when asked a question about when states could reopen, boldly asserted that he would tell them when to open and that they would do what he wanted them to do, and that any power that they had basically was derived from him, from his authority as president, as executive. And in fact, that's not true. It was pointed out that public health powers are generally state and local matters, and that the federal government would not have the power to do those things that the president claimed. This was an example of a conflict in the scope of the executive's power in the field of public health. The separation of powers under the Constitution is critical to understanding how the Constitution works. We have three co-equal branches of government, meaning that no one branch of government is supposed to be dominant or more powerful than any other. And those three branches of government are the executive, which we should think of as the President of the United States. Occasionally, you'll see me write that in shorthand as POTUS. Understand that to mean President of the United States. On the state level, the governor is the executive. The executive acts through agencies and departments and enforces the public health laws. The second branch of government is the legislative branch, which is Congress, that's the Senate and House of Representatives, and the state legislatures on the state level. They write and enact the laws. They amend them when necessary. Of course, the president has to sign a law before it becomes a law, but we'll talk about that process later on. And the third branch of government is the judicial branch. These are the courts. At the top of the federal system, we have the Supreme Court of the United States. Again, I will shorthand that sometimes by writing SCOTUS, SCOTUS. By that I mean Supreme Court of the United States. The state systems have also courts, and they are organized much like the federal courts, with the Supreme Court at the top and the trial courts at the bottom. Courts are there to decide cases. The Supreme Court and the federal courts are there to determine whether or not laws are consistent with the Constitution, and they are bound by precedent. We'll talk about that later as well. We have the concept of preemption. Preemption simply means that federal government, federal laws, when they come into conflict with state, tribal, or local laws, take precedence. That means that under the Supremacy Clause of the Constitution, which is found in Article 6, federal law will rule in the case of a conflict with a state law as long as it is an authorized power. The federal government does not have the power to act in all circumstances, but its areas where it can act are enumerated in the Constitution. You'll find them in the Commerce Clause and in the taxing powers. And we'll go over a few more examples of where the federal government can act. But in the event of a conflict, the law of the higher government will prevail. And you see a small chart, sort of like a Venn diagram, but not exactly, which shows the concentric circles of preemption, with the federal government, the large blue circle, state and tribal, red in between, and local. Local would be municipal and county government at the very center. Federal public health powers are derived from Article 1 of the Constitution. Take a look at your Constitution. I've assigned it as reading for week 1. I want you to read Article 1. I want you to find the specific powers which have been granted to the federal government. And those are basically in 4 categories. 1 is the regulation of interstate commerce. Think of this as the business that goes on from state to state. They have also the power to tax. They have the power to spend federal money, that is federal tax money. And they have the power to make treaties. Think of the Paris Climate Accords. Think about the NAFTA treaty, which has recently been replaced by the new treaty between the United States, Mexico, and Canada. These are treaty powers, not necessarily in those cases having anything to do with public health, but certainly the Paris Climate Accords do have something to do with um, public health in the sense that the environment, the ecology are all tied in very, very closely with the public health concerns that people on the streets are concerned with. Traditionally, the federal government has acted in the area of the environment. Think about the Environmental Protection Agency and the Clean Water Act and the Clean Air Act, and the government making sure that our human activities are not having a deleterious effect on the environment. The environment is directly tied into our public health. Transportation safety is another area, um, national speed limits and things like that. And national security, of course. A public health crisis could elevate to the point where it becomes a national security issue. Think about COVID 19. If it had penetrated our armed forces to such a degree that a large a part of our military capability had been compromised, this could obviously be considered a national um, security crisis, and the federal government can act under those circumstances. State powers are much more broad than federal powers in the public health field, and this again is because of the 10th Amendment. The 10th Amendment is the reserve clause, and it says that any power which is not specifically given to the federal government, i.e., those we just talked about a few moments ago, are to be exercised by the states. And state power comes in two categories. One is called police powers, and the other is called parens patriae. Police powers are the inherent powers of states to enact laws for the health, safety, morals, and general welfare of its people. This allows the state to test and screen and vaccinate, isolate, impose social distancing protocols, governors writing executive orders limiting travel and closing businesses. These are all exercises properly of the state police powers. Parens patriae comes from the Latin, literally means parent or father of the country. It allows the state to act on behalf of individual citizens. Um, this comes into play when we're talking about the protection of children or the aged. Think about DYFS in that context. It comes into play when we're talking about the institutionalization of the mentally disabled, those people who can't act on their own, who don't have autonomy because of their mental state. The state will act on their behalf. And prisoners, inmates who are incarcerated are within the custody of the state, and the state must treat them under the parens patriae doctrine, making sure that they have all the basic requirements needed to live. Um, this comes into play in the COVID-19 crisis, and we'll talk about it more later in coming weeks. But in the prison population, the virus has been, in some places, rampant, leading to a very unsafe environment in the prison. The state has an obligation to keep the prisons healthy. Do they do a perfect job of it? No, but that is their legal obligation to provide safe and sanitary conditions in prison. Local and tribal powers also have public health authorities. Um, Individual municipalities in the COVID crisis have done such things as close their local parks, impose curfews, um, require people to wear masks when they patronize stores. And this is an example of local government, municipal government acting in the public health field. As mentioned before, the legislative process is the process by which laws are created. How does a bill become law? We're all aware that these laws exist. Everything from the laws which establish speed limits and the criminal laws under which criminals are prosecuted are all statutes or laws, and they all originated with legislatures. In the federal case, these laws come from Congress. Congress is what we call a bicameral legislature, two houses, Senate and House of Representatives. Most state governments also have bicameral legislatures, and they pass laws in much the same way. But let's focus on the federal process for now. How does a bill become the law? Well, basically, a bill starts with an idea. The ideas sometimes come from medical research, identifying a problem, social issues, lobbying groups or special interest groups bringing an issue to the attention of Congress. And so having begun with an idea, someone writes it up into what they call bill form. This is the very first form of a law. The actual text of the law is written down by either a senator or a congressman, and it is introduced into the Senate or the House. Once it's introduced, there are committees in the House and the Senate which convene to elicit public comment on that law, to get opinions, to consider how the law will work, how much it will cost to administer, and they will take all that testimony and all that evidence and either amend the law, change the law, or decide that it was not a good idea to begin with. A bill which is introduced in the House, for instance, will have to pass the House by a majority vote. Once a majority of the House votes for this bill, it is sent over to the Senate, because in order to become a federal law, a bill must be passed by both houses of Congress and signed by the President. The Senate will usually introduce its own bill, which is similar to, but sometimes a little bit different from the House bill. They will vote on it. If they pass that bill, then what's left to do is to reconcile the differences between the two bills. And they'll do this by conference committee. A conference committee is a committee of senators and congressmen who get together and talk about the differences between the two bills and try to mold them into a single bill that both houses can agree upon. If they accomplish this, then the final passage of the reconciled bill goes to the House of Representatives and to the Senate. If both houses pass it by a majority vote, it goes to the President's desk. The President then has options. The President can sign the bill, in which case it becomes law. The President can veto the bill within 10 days of it being delivered to him. And by vetoing it, it does not become law. He can enact what's called a pocket veto, which means at the end of a legislative session, he can just not act on it. And if the Congress expires for the term while he has the bill and has not acted on it, it does not become a law. Other than the pocket veto, if the President does nothing with a bill, neither vetoes it nor signs it, after 10 days it will become the law anyway. Let's assume the President has vetoed a bill. He has some problem with it and doesn't like it, wants it changed, and vetoes it. It then goes back to Congress, the Senate and the House of Representatives. If they wish to override that veto, that is, force it into law, even though the President did not want it, they would have to revote on that law and pass it by a 2/3 vote of both houses. Very difficult process. Generally, when the President vetoes a bill, The Senate and House of Representatives will go back to their committees and try to come up with a compromise that will be palatable to the president. I have included in the Module 1 materials a video link, which if you click on is a somewhat humorous but very informative video on how a bill becomes a law. And take a look at that if you would. I think that along with the reading that you have done and the lecture that hopefully I have made clear here today will give you a better sense of how a bill becomes a law and what a big, complicated process it can be. The regulatory process is equally important. Regulations are a function of the executive branch. The executive branch doesn't write laws or pass them, although they do get to sign them. But the executive branch, the president, establishes agencies. They are part of the executive branch of government. When a law is passed, the authority to enforce that law is assigned to one of those agencies. An environmental law would be assigned to the Environmental Protection Agency, for instance. A health care or public health bill might be assigned to Health and Human Services. The heads of those departments are appointed by the president, and they're in charge of enforcing them. Sometimes a law will express the general intention of Congress in a particular field, but it lacks detail. The people on the ground don't know exactly how to administer it, and they need a roadmap. So you should think of regulations as that roadmap. And the agencies appointed by the president are empowered to come up with regulations. Regulations, in many cases, in terms of sheer pages and words, are many times the size of the bill that they address or the law that they address. A law which is 100 pages long may end up with regulations that are 500 pages long because it gets into great detail. The regulations should be thought of as filling in between the lines of legislation. They provide practical guidance, detail, and set forth procedures for administering that law. Lastly, we talk about the structure and the role of the courts, the judiciary, the third branch of government. The judiciary is set up by Article 3 of the Constitution. The executive is Article 2. The federal courts structure, which we'll deal with primarily here, handle certain kinds of cases, those which arise under the Constitution or those which arise under the laws of the United States, that is, federal laws, or between citizens of different states, that's called diversity jurisdiction. And the courts are organized basically on 3 levels, and there are more than this peripherally, but we're not going to deal with them in this course. At the very bottom, we have the trial courts, and they're called federal district courts. There's at least one of these in every state in the United States, and in most states, more than one. There are then circuit courts of appeal. These are, as they are labeled, courts of appeal. There are courts to which parties can appeal determinations by district courts. A circuit court will embrace a larger geographic area, sometimes parts of more than one state, and they have the power to affirm or reverse the decisions of the lower courts. The Supreme Court handles appeals from the Circuit Court of Appeals and other appeals which are permitted to come up directly. But the Supreme Court is the ultimate court, and the and it's one of its chief roles is to determine whether or not laws which are challenged before it are consistent with the Constitution. State court systems likewise have Supreme Courts, courts of appeals, and trial courts, modeled pretty much the same way with pretty much the same functions. Primarily, courts are responsible for resolving conflicts between individuals, but in the public health field, they have a role in resolving conflicts between individual liberties and the public health laws which are enacted by the federal government and the states. Think of them as a referee which decides these disputes. These disputes are very important because these liberties are very important. They're cherished and they're guarded closely. However, when you have a public health crisis on the magnitude of the COVID-19 pandemic, the government must act swiftly and decisively. When these two forces come into contact, into conflict, into collision, it's up to the courts in many cases to decide the limits of the government's authority to act. How do courts decide cases? Well, with reference to the Constitution, first of all, because the Constitution is the supreme law of the land. We use a common law system in the United States, which means that judges in deciding cases are bound by the decisions of other judges in prior courts. So that we'll find later when we study the case of Jacobson versus Massachusetts, a case which is well over 100 years old, that our courts today are still relying on the rationale of the Jacobson case and consider it binding on their decisions today. This is called precedent, and it's the central feature of what we call common law. Aside from common law, we have statutory law. These are the laws which are written into books, and these are the laws which Congress enacts using the process we described earlier. And although it would be nice to think that the outcome of any given case is sort of formulaic and it resolves to a math problem, give me the facts, let's add the law, and that will equal an outcome. Whether or not that's a reality or a fantasy, it's food for thought. And as we go through the cases that we'll study in this course, I want you to think about whether or not the result was fair, was the result or the decision logical, or was there some other factor at play? When we get to the interpretation of the Constitution, we have two schools of thought, and you'll see them coming into play in some of the more modern Supreme Court decisions we will deal with, in particular the ones which are dealing with the Affordable Care Act, which we'll probably touch on in the healthcare portion of the class, but in others too. The two schools of thought are strict construction or originalism and loose construction. A strict constructionist or an originalist, as some of the justices of the Supreme Court are today, would argue that there are no rights but those which are explicitly enumerated by the Founding Fathers in the Constitution. That is, if the right can't be literally found within the four corners of the Constitution, then it doesn't exist. They think that the Constitution should be interpreted in accordance with the original intent of the founders in 1789. Now, much has changed since 1789, and this is the point of the disciples of loose construction, the people who believe that the Constitution is a living document. I have attached to Moodle for week 1 a copy of Supreme Court Justice Thurgood Marshall's bicentennial speech, bicentennial of the Constitution, that is, entitled The Constitution, a Living Document. I want you to read that. I have highlighted sections of it, but I would like you to read it all. I want you to bear in mind that Thurgood Marshall was the first African American appointed to the United States Supreme Court. He served a long time. He served very well. A brilliant man. The Constitution, as he sees it, must be interpreted in light of the moral, political, and cultural climate of the age of interpretation. Therefore, it's a living document. It evolves. Its meaning changes, not radically all the time, but slowly with time. He uses the example in the article of uh, the fact that when the founding fathers made the Constitution, slavery was legal and slaves could not vote. Even freed African men could not vote, and women certainly could not vote. Now, of course, there is no slavery, and the extension of rights to vote have been extended. So, obviously, in those cases, as we have lived and learned, our understanding of the Constitution and its central meaning has also evolved. So, why it matters. The Ninth Amendment, which are the non enumerated rights, and the natural law. Natural law is that body of law that legal philosophers talk about, the basic right and wrong of life. It's not permissible to steal from your neighbor. We don't need Congress to pass a law to know that we shouldn't steal or take innocent life. But many of the rights that are implicated in the public health field are not enumerated in the Constitution. And this is why how we interpret the Constitution is very, very important. Some of those which are not enumerated in the Constitution are the right to privacy and reproductive rights. Roe versus Wade was based on a finding by the court that there was a privacy right. Privacy is not mentioned anywhere in the Constitution. Even the right to marry is not mentioned in the Constitution. The right to travel is not mentioned in the Constitution, but there are basic freedoms, and the Constitution does guarantee us the right to life, liberty, and the pursuit of happiness. And that pursuit of happiness is a very broad freedom. I thought I would walk you through this week's reading and writing and forum assignments so that you can see where on Moodle I will place those from week to week, and I will be consistent in how I communicate assignments over the 11 weeks of the course. So you'll see here that I've assigned the reading of chapters 1 and 2 in Public Health Law in a Nutshell by Hodge. And I've also assigned you to read U.S. Constitution Articles 1, 2, 3, 6, and the 10th Amendment. All of those can be found in the PDF file U.S. Constitution, which is attached above. And as we mentioned earlier, I would like you to read the short Thurgood Marshall speech, The Constitution as a Living Document, and watch the video on how a bill becomes law. Further down in the module, you'll see that the forum is indicated. And the Module 1 forum, as I open it, will require you to identify and rank individually 3 public health issues that are important to you, justifying the reason why you have ranked your top choice as number 1. Below that, you'll see a section entitled Complete Assignments and Assessments. And here, your Module 1 writing assignment, as I open the Dropbox, is indicated within. You'll respond to the questions indicated and submit through the Dropbox. In addition, since we are online and will not be meeting face to face and will not have a chance to get to know one another in that way, I'm asking you to provide a short biography of yourself, indicating where you are in your educational process, what your aspirations are for the course, what your professional goals are, and hopefully I'll be able to use this information to tailor the course as we go forward and try to deliver the kinds of content that you'll find most meaningful and useful. As always, I will post a screencast-o-matic lecture, which I would encourage you to listen to and take notes from as if we were face to face. This will not only amplify some of the concepts in the readings, but it will maybe prompt some questions in your mind, which you can then communicate to me through a forum or through email. The PowerPoint on which the screencast is based will also always be posted so that you'll have that as a resource as we go forward.